The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some landlord-tenant issues and family law cases. Now, today we're going to talk about calling witnesses in Iowa divorce and custody cases. In divorce and custody cases, a party often wants to provide the testimony of witnesses. A party may wish to call somebody who has witnessed a party's parenting skills. Perhaps a witness was present during an instance of abuse or neglect. Witness testimony is one of the most common forms of evidence offered in these kinds of cases. Now, what are the rules that govern witness testimony? Witness testimony is governed by the Iowa Rules of Evidence, Iowa Court Rules, Chapter 5. The Rules of Evidence provide two categories of witnesses. There are experts and lay. A lay witness are witnesses who are not testifying on an issue requiring some kind of specialized knowledge. A lay witness gives opinions. These opinions are limited to those that are rationally based on the witness's perception, helpful to clearly understanding the witness's testimony or determining a fact and issue, and not based on scientific, technical, or other specialized knowledge. These witnesses may be friends, family, or community members who know the party and can speak about non-technical aspects of the case. Examples could be the opinions on the care a parent provides, specific instances of a party being a good parent, or recounting an argument between the parties that the witness observed. Generally, a court is more likely to give weight to testimony from a non-family member witness, as they are more likely to be impartial. Examples could include daycare providers, pastors, religious leaders, or other parents. However, there are circumstances where a family member may still be a valuable witness, especially if they come off as credible. Remember, parties have the opportunity to cross-examine all of the opposing parties' witnesses. If the witnesses are aware of any information which would be helpful, they should be asked questions about it on cross-examination. Now, how does a party get a lay witness to testify? Oftentimes, a party can get a lay witness to testify simply by asking them to come to the courthouse and testify on their behalf. However, there is a chance that the witness will not show up. The best way to make sure a witness shows up to court is with a subpoena. A subpoena requires someone to come to the courthouse and testify in court. It's a court order to appear, and if they don't do so, they could be held in contempt of court. The clerk of court or attorney issues a subpoena to a party requesting it. Someone who is 18 years or older and not a party in the case must serve the subpoena. There is not a specific amount of time that the subpoena party must be given, but the party or attorney must not subject the subpoena party to an undue burden. Now, what is an expert witness? An expert witness is a witness who has qualified knowledge, skill, experience, training, or education to give opinions on certain topics. Their specialized knowledge helps the judge determine the facts and understand evidence in the case. An expert looks at the underlying facts or data informing its opinions. The facts and data need not be admitted as evidence if someone in the expert's field would have normally relied on that information. The court may appoint an expert witness. Though parties can contest the necessity of the appointment, the court may appoint experts over objection. The court must inform the experts of their duties in writing and file a copy with the clerk. Or the court may inform the expert orally at a conference in which the parties participate. The expert must advise the parties of any findings it makes, may be deposed by any party, may be called to testify by the court or any party, and may be cross-examined by any party. Parties are still free in this instance to call their own experts. Should a party call expert witnesses in divorce cases? One of the most common reasons a party calls an expert witness is if there are factual issues involving financial assets in divorces. This could include value of assets, value of property, value of a business, structure of a business, or other financial matters. These experts could be CPAs, bookkeepers, or real estate appraisers. Expert witnesses may be called to testify about any other technical issue which may involve the assets or health and wellness of the parties or children. For instance, social workers may be known to or may testify in custody proceedings. How many witnesses should a party call? There are generally no limits to the number of witnesses a party may call, but it's not as important as using quality witnesses. 3 to 5 good witnesses will likely be more than sufficient, though there are cases where more may be required, or when less are simply enough. Are there any witnesses in temporary matter hearings? The general rules and guidelines for witnesses also apply to temporary matters hearings. However, in these hearings, the court will not hear in-person testimony of the witnesses. The court will typically allow parties' witnesses to submit affidavits to the court for the judge to consider, generally with a capped number of allowed witnesses. If you have any additional questions, feel free to reach out to our firm. Thank you very much and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.